Good evening. On behalf of the Center for ADR Research and Practice, I welcome you all who have joined on Zoom, YouTube, and Facebook platforms for this lecture. Center for ADR Research and Practice is a lawyers collective that aims to promote alternate dispute resolution. We have been in the forefront of advocating mediation as a principal ADR tool for resolution of disputes. And the new Mediation Act is a vindication of our efforts. Topic for the online lecture today is understanding the new Mediation Act. There are many questions that linger in our mind regarding the new legislation. Before I proceed further, can I request you to keep your microphones switched off? I think that Rajesh, your microphone is on. I don't know whose microphone is switched on, so I can hear myself here. Thank you very much. As I was pointing out, there are many questions that linger in our mind regarding the new legislation. Many a times we ask ourselves as to what does the new Mediation Act have in store for its stakeholders? How does it propose to use mediation to achieve its avowed goal of reducing litigations in courts? How is the Act going to impact the legal process in India? That is a question that comes to the mind of many lawyers, because there are some quarters who believe that this is going to have a great impact on advocates and their practice. What does the Mediation Act have in store for the litigants? Ultimately, they are the biggest stakeholders. How is it going to impact the functioning of the court system as we know it? Does it have any impact on the conciliation process as we know it now under the 1996 Act? Foremost, how does this Act envisage mediation as a process to facilitate the resolution of dispute? And one important aspect that comes up and that is being asked by everyone out there is, will making mediation mandatory be something that is desirable? Because the attempt to make mediation mandatory already in certain areas like family disputes and in commercial disputes have had its own supporters and detractors. So this new legislation actually throws up a number of questions regarding mediation, and these are all of great interest and concern for litigants as well as advocates. So to answer these questions and more, we have today with us Mr. Rajesh C. Muttat, who is an expert in ADR. Mr. Rajesh C. Muttat is a lawyer by profession. He did his post-graduation in law from Staffordshire University, UK, where he was an ODA scholar. He was the chief knowledge officer at Allen and Gledhill, one of the largest and leading law firms in Singapore. Mr. Rajesh C. Muttat was the director of the ASEAN Legal Information Center, a center co-established by the University of Kuala Lumpur. Mr. Rajesh C. Muttat has seen the working of statutory mediation in ASEAN countries and has been a part of its working there. So he is the best person who will be able to tell us as to what is in store for us, because he has seen it from very close quarters. Even though Mediation Act as a statutory instrument is new to us, it has already been there in ASEAN countries. And Rajesh C. Muttat has been so closely watching the developments there, and he was a participant there also. So with his wide experience as an ADR professional abroad, Rajesh C. Muttat will be able to tell us what we want to know about the new Act. Over to you, sir. Rajesh.
Thank you. Thank you, Shyam. And good evening, everyone. Thank you for coming. Let me start with a riddle. I promise you this is the most exciting part of my entire session. Once upon a time, there lived 3 ladies as neighbors in a village. Great friends they were, who spent a lot of time and did a lot of things together. Life was a smooth sail until one fine day when they had a little quarrel over an orange. There was only one orange and all the ladies claimed it. Lady A claimed it. After all, the plant which bore the fruit was on her land. Lady B claimed it. She was the one who planted it after having secured the sapling from some remote region some years ago. Lady C also claimed the orange. She was the one who nurtured the plant, put the manure, watered every day, and tended with care. The little quarrel grew big. The relationship started to get strained. Their children tried their best, but no avail. The quarrel is growing bigger. Now, who will you give that orange to and why? I want you to tell me why. You can use the chat. I mean, if anyone wants to speak up, please do. Or if you want to put your response in the chat, do respond as vigorously as you could. As I said, this is the only exciting bit in today's entire session. So if you have your answer, please put it in the chat so that I can look at it.
Sir, I know the answer because I heard the story, but I will not say.
Okay, thanks. Thanks for not saying. But let's wait for others to put it in the chat or speak up. Or shall I call somebody up? Or anyone wants to respond in person?
I shall collate it, Mr. Rajesh. You can go ahead with the lecture. I shall collate the chats and I shall put it as questions to you later on. Please go ahead.
I see some of them. It looks like some of them are suggesting that it should be divided equally. Some says it should be divided in a particular ratio, and some says give it to A. Satya says distribute them periodically. Ramadurai, but we have 3 people asking for it. So peels for one, inner fruit for the other. What happens to the third one? All right, so as I see it, the comments are you can possibly divide them equally, divide them in a particular ratio, or give it to one particular person. Some says it should be Lady A, given the land is hers. Interesting answers, thank you. The story continues. The children of these ladies, desperate to end the growing quarrel, brings in a wise man who they know commands everyone's respect. The ladies repeated the claims to him. The wise man nodded to all of them, seemingly approving every one of their claims. Then he asked the ladies, "Ladies, what do you want to do with the orange?" Lady A said, "I want to make an orange juice for my grandkid returning from holidays from the town." Lady B said, "I want to bake an orange flavored cake for my grandkid who is visiting me after a long time." And Lady C said, "I want to grow my own orange garden." The wise man simply cut open the orange, separated the pulp, zest, the skin, and the seeds. He gave the pulp to Lady A so that she could make orange juice, the zest or the skin to Lady B so that she could bake the cake, and seeds to Lady C so that she could dry them and plant them into her orange garden. Everyone hailed the wise man who assisted the parties to resolve their dispute, and everyone lived happily after. This is, of course, a made-up story. What I did this afternoon. It's hyperbolic, exaggerated. Don't ask questions on that. But what I'm trying to say is that if the wise man or the parties had taken a rights-based approach, an approach based on who has the bigger right to the orange, one of them would have gotten the orange, or the orange would have been cut into 3, as some of you suggested, in some proportion, making no one really happy. When the wise man and the ladies took an interest-based approach, what are the real underlying interests, they had an innovative and win-win solution. The point is, mediation allows the opportunity to explore an interest-based approach more than litigation and arbitration. That makes mediation unique as a dispute resolution tool. As we enter the lecture proper, I want to remind you that mediation is simply a way by which the parties resolve their disputes amicably with the assistance of a neutral person. It can be very effective, or not effective sometimes, very flexible, innovative, and it can produce a win-win or amicable solution that preserves an ongoing relationship. Just as we heard in the story. A couple of points. First, this lecture, as we go ahead, may get a bit technical, and for a fuller appreciation, you may require some idea of the concept and practice of mediation and how it is regulated currently. Or in other words, this lecture may be better suited for professionals and students with some exposure to mediation and mediation law, as I make some assumption based on prior knowledge. Secondly, as some of you may have already noticed, the title of this talk is technically wrong. We do not have a Mediation Act yet. It's still the Mediation Bill 2023 as passed by both houses of the Parliament. But since it's expected to be signed by the President soon, making it the Mediation Act 2023, we have taken the liberty to call it the Mediation Act, just for the convenience. And I will refer to sections rather than clauses throughout this lecture. So apologies to the purists among us. And third point is that given the purpose and time, this lecture can only survey the highlights of the Act. We may not have the time to go in depth. Remember, we do not have the rules and regulations yet. We do not have the Mediation Council, the central body for mediation, established yet. And even we don't have an act yet. We are working on a past bill. So an in-depth analysis will be done later. I understand the Center for ADR is planning a detailed workshop at a later date. Now, mediation has been here. In fact, mediation, where one neutral third party assists others to resolve their disputes amicably, was in existence in most civilizations in one form or other. The resolution of disputes by informal panchayats, where the respected elderlies of the villages were appointed as mediators, is often cited as an example of early mediation in India. Greeks have their own, Romans have their own, even Red Indian seems to have some history to mediation. Some even quote from Bible, the Solomon story. Closer to time, the formal integration of mediation into the Indian legal system actually can be traced back to 1947, Industries Disputes Act, for settling disputes out of court. Its innate qualities, I mean, the mediation's innate qualities, and owing also to several external reasons, mediation has taken off both globally and locally as a dispute resolution process. We know that. When I say innate qualities, they include what we have already mentioned: the flexibility, the affordability, innovativeness, the win-win solutions, preservation of ongoing relationship, just as we saw in the story, the control of the parties over the process and outcome. All these innate qualities make mediation unique. It's of course not a panacea, but an effective alternative to the conventional or more established dispute resolution processes. The external reasons, these are innate qualities. Now, external reasons for the rise of mediation include the pressure of cases on the court system. That's what we hear all the time. The pressure of cases on the court system that leads to delayed or even denied delivery of justice. The growth of trade and commerce, both globally and locally, has also created a need for a cost-effective and time-effective dispute resolution process, and that is yet another external reason. So as a result, you will see increased use of mediation as a dispute resolution tool. In fact, in India, court-annexed mediations, which you are all familiar with, have played a huge role in that, in popularizing mediation in India. You see a lot of academic debates these days, the carving of a niche profession for mediators. Many are getting trained, and even a UN Convention on Mediation, which happened in 2020, the Singapore Convention. This growth of mediation, including the increased usage in practice, has naturally exposed some gaps and shortcomings. There is this issue of enforcement of settlement agreements, use of mediation to delay dispute resolution, quality of mediators, their professional standards, protocol for the conduct of mediation, confusion springing up from the use of conciliation and mediation interchangeably or otherwise, reference of mediation in several statutes all over the place in an unorganized manner. All these required some sort of solution. There was also pressure, actually there is still pressure from the international community to have an effective domestic law for mediation, especially since the coming into force of the Singapore Convention on Mediation. So a proposal for a comprehensive treatment, perhaps in the form of a standalone statute to promote and regulate mediation, has been made from various quarters, including the Supreme Court. I can't remember the case on the top of my head, but it was in Justice Sikri's judgment in which he called for a Mediation Act. There were some dissenting voices as well who did not want mediation to be over-regulated so that its essence, the party autonomy and consensual nature, is not compromised. However, on the balance, the idea of having a comprehensive, standalone statute gained prominence and eventually the official acceptance. And hence, we have the Mediation Act 23. The stated objectives are, one, to promote and facilitate mediation, especially institutional mediation, enforcement of mediated settlement agreements. That means, the settlement agreements which results from mediation, there is a provision, they provide for the enforcement of them, to provide for a body for the registration of mediators, and to encourage community mediation and online mediation, two new concepts. So if you look at the timeline of the Mediation Act, you will see that there was a draft bill as early as October 2021, and then the original bill was introduced in the Rajya Sabha in December 2021, and finally the amended bill, as passed by both houses of the parliament almost 2 years and a select committee report later in August 2023. As I said, it's yet to become an act, but we do expect that shortly. We do not have that much time, so that what I will do is, I will bring to your notice 10 key things I believe that you should know about mediation. 10 broad observations. Firstly, and perhaps most obviously, the Mediation Act consolidates the law on mediation in India, or whatever elements of regulation we have on mediation, into one central statute, the Mediation Act. In the process, you will see that the Mediation Act overrides, subsumes, amends other laws. For example, the Mediation Act will have an overriding effect on all other laws except some listed acts. I don't want to list it out now, but an example would be Industrial Disputes Act 1947. The Mediation Act do not have an overriding effect on the Industrial Disputes Act 1947. The Act goes on to amend several statutes. Look at the Indian Contract Act, for example. We know that Section 28 of the Contract Act makes agreements in restraint of legal proceedings void. And we already have arbitration as an exception. Mediation is now included along with arbitration as an exception to Section 28. So entering into a mediation agreement is not void under the restraint of legal proceedings. There are also amendments to Code of Civil Procedure, notably the Section 89, the controversial 89 section, Legal Services Authorities Act, and many other acts. Perhaps we may also want to note that the new act, the new Mediation Act, subsumes conciliation section placed under Part 3 of the Arbitration and Conciliation Act 1996. We never had mediation, only conciliation. But now, conciliation will be treated as mediation and will be governed by the Mediation Act. That part 3 of the Arbitration and Conciliation Act will no longer exist. It will be removed, subsumed by the Mediation Act. For the details, Act extends to whole of India. It applies to mediations conducted in India, both domestic and international. There are some confusion regarding the definition of international mediation, and that confusion will be more complex when we sign or ratify the Singapore Convention, but that we will deal with later. It does not apply to mediations conducted outside India, and also to mediations commenced before the coming into force of the Act. Mind you, the Act has not come into force yet. The Act, as a matter of course, defines mediation. It defines as a process whereby parties attempt to reach an amicable settlement of their disputes with the assistance of a third person. And that third person is called a mediator, and who simply is a facilitator with no authority to impose a settlement on the parties. So there are a few key elements. Mediation, it's a process whereby parties attempt to reach an amicable settlement of their disputes themselves with the assistance of a third person who is called a mediator. But the mediator is just a facilitator. He has no authority to impose a settlement on the parties. And that is why it's consensual, and that is why it's called mediation. Mediation is also very usefully defined to include certain new concepts of mediation, like pre-litigation mediation, online mediation, community mediation, conciliation, and a few others as well. Defining mediation in a Mediation Act appears the most obvious thing to do. It is. But in the Indian context, it serves an environmental purpose as well. It saves a lot of paper. That much have been written on the difference between mediation and conciliation. You look at Google articles, speeches, academic theses, while the fact is there was no difference at all to start with. I know some of you may immediately disagree with me, but thanks to the disconnect forged somewhere and precipitated by the Arbitration and Conciliation Act of 96, Section 89 of CPC, and even some of the Supreme Court decisions, an artificial difference was forged between two really interchangeable terms, conciliation and mediation. And we Indians, like we do, celebrated it and actively distinguished them, making us out of line to what was happening outside India. The Act finally and thankfully settles the mediation versus conciliation battle. Mediation is defined to include conciliation, and the relevant changes are made to reflect that throughout the Acts. The Act now says that when parties try to settle their dispute with the help of a third person who facilitates settlement, it is mediation, no matter what it is labeled. The Act accepts the global practice of using mediation and conciliation interchangeably. For our practices, this may be a huge change. Well, basically, what's in a name? As Juliet famously said, that which we call a rose by any other name would smell as sweet. As part of the consolidation process, the Act also introduces, as I said before, and explain various types of mediation. International mediation, for example. It is defined. It is defined to include a commercial element as well as a foreign element. It must be a mediation under the Act, and it must relate to a commercial dispute. These are the conditions for an international mediation. At least, and it must be, as I said, it must be under the Act, it must relate to a commercial dispute, and at least one of the parties to that mediation must be a foreign national or resident or a body corporate or association or body of individuals with a place of business outside India or a foreign government. So basically, for a mediation to be international, there should be a commercial element and a foreign element. Domestic mediation is not defined, but it's safe to assume that it is a mediation under the Act, which is not international. Now, court-annexed mediation, it is defined, something which we are familiar, but the Act defines it as a mediation conducted at the mediation centers established by any court or tribunal. So you will find whatever happens at the the Kerala Mediation Center, the High Court, will be court-annexed mediation. We know that anyway. The Act then introduces something called online mediation. And that took off big time during the COVID times. These are mediations conducted electronically. We know that again, but this Act defines or through computer networks. Community mediation is yet another new creature. That is a mediation to settle disputes that are likely to affect peace, harmony, and tranquility amongst the residents or families of any locality. So when that happens, when a mediation to settle disputes that affect the peace and harmony and tranquility of a locality, then it is called community mediation, and the Act provides for how to conduct community mediation. Then the Act defines and elaborates on something called pre-litigation mediation. It is a major disappointment, I must say, as it stands now. We will discuss why towards the end of this talk. For now, understand that pre-litigation mediation is a mediation voluntarily undertaken by the parties prior to filing any suit or proceedings of civil nature before any court or tribunal. Pre-litigation mediation, exactly what it says. So in summary, we saw that the Mediation Act consolidates the law of mediation in India. And for that purpose, it overrides, subsumes, amends other laws, and it defines mediation and explains certain types of mediation. Now, when it comes to alternative dispute resolution process, any alternative dispute resolution process, its success often depends on how the local legislation, not just the local legislation, also the international conventions and the courts support it. So the real test of a legislation in such cases is how much it supports the essence of the dispute resolution process in question and how well the legislation empowers or limits the role of courts. The essence of mediation, I hope you won't quarrel with that, is party autonomy, that the parties get to control the process and outcome of mediation. That brings us to the second point of today, which I want to elaborate, that the Act, as I see it, emphasizes party autonomy, and it does a very good job at it. You will see that the parties are free to commence mediation if and as they like, if you look at the Act. they can decide to agree to mediate or not mediate. Well, there is an exception to that consensual nature of agreement to mediate in Section 7, where the courts have the authority. I disagree with in principle, but courts have the authority under Section 7 to refer the parties to undertake mediation. It's an exception, but everywhere else, the parties can choose whether or not to mediate. Even in Section 7 referenced by the courts, there is no obligation to settle. Then you see the parties are free to continue with mediation or withdraw from mediation as they like. There was some prohibition against such withdrawing from mediation until after the parties attend 2 sessions of mediation in the original bill, the first one introduced in Rajya Sabha in 21 December. There were some cost sanctions for such withdrawal in that bill, but the amended bill removes even that. So basically, you are free to continue or not continue with mediation at any time. And the parties are free to settle or not settle their disputes even after going through mediation. As I mentioned, even though the court refer the parties to undertake mediation under Section 7, there is no obligation to settle. In fact, a mediator is duty-bound to inform the parties that he only facilitates the process and will not impose a settlement or give any assurance that mediation will result in a settlement. So that is mandatory on the mediators to say so. So the party autonomy when it comes to settlement or not settlement is emphasized as well as it can. The parties can decide to settle all or any of the disputes before them, or even those disputes which are not part of the original reference. So I can have a mediation agreement with you, and then I can decide some of the disputes which we agree to refer to mediation, or all of those disputes, and I can even actually bring disputes from outside the scope of the mediation agreement and settle them. Parties are free to do whatever they want. So there is almost absolute party autonomy at all stages of mediation, at the commencement, during the pendency, and at the termination. The party autonomy goes even further. The parties are free to decide on several factors before, during, and after mediation. The parties can decide on the name and procedure of appointment of mediators. The party preference is an important consideration, even when mediation service providers decide the mediator. Parties have a say in the termination and replacement of mediators. Parties can decide on the place, language, mode, online or offline. The parties can agree. How the cost of mediation should be borne, again, something the parties can agree. Which court or tribunal shall have territorial jurisdiction over mediation, the parties can agree. Whether to extend the time limit to complete mediation, I mean, of course, they can only do it for 60 more days. The parties can agree. Whether to register the settlement agreements, they can agree. So the parties have control over all these factors. And that is why I said the Act upholds the essence of mediation, the party autonomy. Now that we have found that the legislation recognizes party autonomy, and thus the character of mediation to a great degree is supported, let us see how the Act defines the role of courts as far as mediation is concerned. That is my third point. The Act, as I see it, sets out a facilitative role for courts. None of us want parties to a dispute resolution process running to the court at every possible step, thereby delaying and to some extent sabotaging the process. With that in mind, the courts are given a facilitative, my opinion, a minimally invasive but critical role in mediation. As I mentioned before, the courts are empowered to refer the parties to mediation at any stage of the proceedings before it. It sounds like an exception to the rule of party autonomy, but I guess in practice, although I disagree in principle, this may help the parties to get that push to mediate. They don't have to settle, but they just have to undertake mediation. So in a way, at least some of the industry people or commentators may agree with this particular power for the courts to refer parties to mediation without their agreement. At least in such cases where the court refers parties to mediation, courts have the power to provide a suitable interim relief to protect the interest of any party in such cases. That is an important one. You know, if an emergency relief is required, you can actually approach the court. But apparently, I mean, I don't think it is intentional. It's a bit of a mismanagement of sections. Apparently, only in those cases where the court refers parties to mediation, this interim relief is available. Make no sense, but at least we have that for those kind of mediation. The courts also, again, I mentioned this before, provides territorial jurisdiction to mediation. Every mediation, the Act says that shall be undertaken within the territorial jurisdiction of the court of competent jurisdiction to decide the subject matter of the dispute. This is critical when it comes to enforcement and challenge of mediated settlement agreements. Now, the courts may also refer some of the compoundable offenses, including matrimonial offenses, to mediation, which are not otherwise fit for mediation. But the outcome of such mediations will come back to the court for its consideration in accordance with law. There are some, generally, criminal cases are not mediatable, but these are exceptions. The courts can actually refer compoundable offenses. Of course, non-compoundable offenses are entirely out of the mediation framework, including matrimonial offenses can be referred to mediation. But the outcome of such mediations cannot be on the agreement of the parties. It has to come back to the court for its consideration in accordance with law. The most important role of court is when a party seeks to enforce or challenge a mediated settlement agreement. Where a successful outcome emerges from mediation in the form of a mediated settlement agreement, and where a party refuses to comply with the terms, the courts come into play. A critical role, enforcement of mediated settlement agreements. So nothing much to complain about the role of courts as provided in the Act, except that I wish there was some provision that allows a stay of proceedings where there is a breach of an agreement to mediate. That we will discuss when we talk about mediation agreements a bit later. Now, the fourth point, which I want to mention today, is that the Act provides an indicative list of non-mediatable disputes. Non-mediatable disputes. I'm sure that you're familiar with the idea of arbitrability. That certain disputes and matters are regarded as not capable of arbitration owing to legal and public policy reasoning. Similarly, not all disputes and matters are fit for mediation. Same reasons, legal and public policy. I'm taking the liberty to use non-mediatability or non-mediatable. It simply means something that is not fit for mediation. Mind you, it's a coined word, not a defined term. The Arbitration Act does not set out non-arbitrable disputes, neither in broad categories or as a specific list. Very recently, the Supreme Court in Vidya Drolia versus Durga Trading Corporation has classified non-arbitrable matters into 3 or 4 broad categories. Thus, matters relating to actions in rem, and sovereign and public interest functions of the state, matters affecting third-party rights, those requiring central adjudication, matters that are made non-arbitrable specifically by a statute. All of these are held non-arbitrable. Same reasons, some are legal, some are public policy reasons. The Mediation Act goes a step further and provides an indicative list of non-mediatable disputes. It is in the first schedule. Section 6, read with first schedule, just in case you want to refer. In fact, all the broad categories mentioned by the Supreme Court in the context of arbitration are more or less listed here. You will see that you cannot mediate declarations having the effect of right in rem, disputes which have an effect on the rights of a third party. There is an exception, but rights of a third party generally you cannot mediate. You cannot mediate disputes which by law are required not to be submitted to mediation. You cannot mediate disputes involving prosecution for criminal offenses. There are many more. Suits for declaration of title against government, disputes relating to claims against certain persons, minors, deities, persons with intellectual and other disabilities. You cannot mediate disputes relating to claims against those persons to protect them, obviously. Disputes relating to tax and land acquisition matters are not mediatable. Disciplinary proceedings against professionals before any concerned statutory authority, say against a lawyer or a doctor, for example, cannot be mediated. Then proceedings against certain boards under certain acts, they are not mediatable. And these acts are specifically mentioned in the first schedule of the Mediation Act. Then there is an interesting proviso to this particular section, which is section 6. As such, the courts may refer any dispute relating to a compoundable offense, something which I mentioned just before, including a matrimonial offense, to mediation. But they are not complete mediation, except because the outcome of such mediations will have to be further considered by the court. But it's mediation nevertheless. So I hope you have some idea of the concept of non-mediatability. That is relevant because there are certain matters which are not fit for mediation. So when we mediate or engage in mediation, these are things which we may have to watch out for. The fifth point I want to make is that the Act ensures smooth and timely conduct of mediation. Remarkable provisions to do that. It does it in several ways by providing a definitive start and end to mediation. If you look at the relevant sections, section 14 and 24, it tells you when a mediation is deemed to have commenced and when it is deemed to have terminated. Importantly, the Act provides a strict time limit to complete mediation. A mediation undertaken under the Act has to be completed within a period of 120 days from the date fixed for the first appearance of the parties before the mediator. The parties may, of course, agree to extend it, but only by a period of 60 days, nothing more. That way, there is some pressure on the parties and the mediator to bring the process to a close. And there is some protection against any party using mediation to delay the entire dispute resolution process. For the smooth conduct, the Act also lays down the manner of conduct of mediation. Of course, the specific manner is yet to be prescribed by the regulations. They are not out yet. But for the time being, the rules governing the conduct of court-annexed mediations is supposed to apply. Now, the mediators, although they are mere facilitators and not adjudicators, play a very key role in the proper conduct of mediation. Obvious. The Act goes on to describe the role and conduct of mediators. For example, it makes it mandatory on the mediators to assist the parties in a, I quote, independent, neutral, and impartial manner, and to, at all times, be guided by the principles of objectivity and fairness. The Act even goes on to say that there are certain aspects a mediator should take particular care during mediation, like exploring areas of settlement and generating options, of course, subject to the freedom given by the parties. The Act, when it comes to the smooth conduct of mediation, the Act also provides a lot of confidence and protection to the mediating parties. Confidentiality provision, for example, unless in very restricted circumstances, the communication, any communication in a mediation, be that the proposals, counter proposals, promises, opinions, suggestions, all should be kept confidential. Again, no mediator or participant in a mediation will be allowed or compelled to testify, to disclose any communication in mediation, except again in very restricted circumstances. Mediators are not to be presented as witnesses in any other proceedings. All of these give the parties confidence to meaningfully and wholeheartedly undertake mediation and work towards a settlement without the fear of his words or action being used against him at a later stage of proceedings. The Act also gives a greater flexibility to the mediators as well as the parties. The mediators are not bound by the strict procedural rules, either under the Code of Civil Procedure or the Evidence Act, now that we have a new evidence bill. Given the importance of the mediators, the Act also sets out fair provisions for appointment, termination, and replacement of mediators, which also indirectly contributes towards the proper and smooth functioning of mediation. As I hope you can see, all these provisions are geared towards proper, smooth, and timely conduct of mediation. A remarkable job, I must say. The sixth point, the Act enforces mediated settlement agreements as judgments of the courts. In a typical mediation, we know that the parties to a dispute mediate, and if they are successful, they settle their disputes, draw up a settlement agreement. In an ideal world, the parties comply with the terms of the settlement agreement. But if one of the parties refuses to comply with the terms, what does the innocent party do? One of the major grievances against mediation is that its outcome, that is the mediated settlement agreement, is difficult to enforce in the event of non-compliance. Mediation is often placed on a lower pedestal than the other dispute resolution processes like arbitration, even expert determination, for this very reason. There's no bite. Until this Mediation Act, the parties who want to enforce a settlement agreement typically take three routes, which I'm sure you're familiar with. First, the contractual route, sue on the settlement agreement for breach of contract. Or they take the consent judgment route or the consent award route. In such cases, they have to start litigation or arbitration, then go and mediate, settle, get back to the court with the settlement terms, and get a consent award or judgment, as the case may be, on those terms. As you can see, none of those routes are particularly attractive. In all those cases, you have to initiate litigation or arbitration, exactly what the parties want to avoid in the first place. It is in this context, the Mediation Act provides that much needed bite to the enforcement to the mediated settlement agreements. It does three things. The Act does three things with regard to enforcement of mediated settlement agreements. First, of course, it defines what is a mediated settlement agreement. Unsurprisingly, and quite straightforward. It is an agreement resulting from mediation between the parties settling some or all of their disputes. That is a settlement agreement. In terms of formality, it must be in writing, it must be signed by the parties, it must be authenticated by the mediator and copied to the parties as well as the institutional mediation service provider. Registration is provided for, but it is an option. The parties need not register. On a substantive front, mediated settlement agreement must not be a void agreement under the Indian Contract Act. It must not be a void agreement under the Indian Contract Act. As such, mediated settlement agreements whose consideration and objects are unlawful, which are uncertain, made without consideration, made by way of wager, etc., will not be deemed as lawful settlement agreements. Here is the most important provision. Mediated settlement agreements, once signed and authenticated, are made final and binding on the parties. They are enforceable, the Act says, in the same manner as if they were a judgment or decree passed by a court. Let me repeat. A mediated settlement agreement, once signed and authenticated, are final and binding on the parties, and they are enforceable in the same manner as if they were a judgment or decree passed by a court. Critical. The Act actually does not stop there. To prevent parties from indiscriminately challenging such mediated settlement agreements, it imposes a strict timeline for such challenges. A challenge of this mediated settlement agreements has to be made within 90 days from the date on which the challenging party has received a copy of the settlement agreement. Within 90 days, maybe a further 90 days if there is a sufficient cause. Plus, such a challenge can only be made on limited grounds, only on 4 grounds: fraud, corruption, impersonation, and non-mediatability. Only on these 4 grounds you can challenge a mediated settlement agreement signed by the parties and authenticated by a mediator. This enforcement process, as I mentioned before, is one of the key features of the Act. It gives mediation the much needed bite. Not anymore a secondary dispute resolution mechanism, something which can stand on its own. I think we are running out of time, but I will try to complete a bit faster, maybe. The 7th point I want to make, if you like the numbers, I have 10 points to make today. The Act establishes the Mediation Council of India. The Act actually requires the central government to establish the Mediation Council of India to promote mediation in India and to develop India as a robust center for mediation. It is a body corporate and it has chairman, full-time members, CEO, and secretariat. It is envisaged as the central key mediation body in India. It is tasked with a lot of duties under the Act, like they have to monitor and report on the implementation of the provisions of the Act. They have to make certain regulations. They have to administer a mediation fund, which is to promote mediation. And they also provide for the conduct of the manner in which mediation is conducted. The key relevance of Mediation Council of India is, however, that it effectively creates a national mediation network around it. For the first time, I think that is interesting and revolutionary. We have a mediation network with Mediation Council of India in the middle. For that purpose, it recognizes, sets standards, oversees other bodies like mediation service providers, mediation institutes, who perform a set of functions for their own. So in the center, you will have the Mediation Council of India, and then the mediation service providers and mediation institutes and the mediators and academics, everyone together, a national network of mediation. Equally importantly, Mediation Council of India sets professional standards for mediation and mediators. It sets the manner of registration, the professional standards, and certification guidelines for mediators. Again, it brings professionalism into mediation. The Act has done well to conceive and enact the establishment of this extremely important institution, around which I'm sure the mediation in India will revolve in the future. The progress of the mediation as a profession and as an industry in India will very much depend on the quality and the energy of this particular council. The 7 things I mentioned so far, the consolidation of mediation law, the emphasis on party autonomy, the defining of the role of courts, provisions for smooth functioning of mediation, explanations on mediatability, enforcement of mediated settlement agreements, and the establishment of Mediation Council of India are good. Some of them are landmark developments. I have 3 more points to mention. The first 2 are not so good, while the last one, I think, is bad, even ugly. That brings me to the 8th point. The Act recognizes mediation agreements to mediate, which is good, but leaves them toothless, which is not good. Mediation agreements, as you know, is an agreement to mediate, are defined and recognized. And if you look at section 4, some formal requirements are prescribed. They must be in writing. It may be a clause in an agreement or a separate agreement. It may be incorporated into an agreement by reference. Parties may agree to submit both existing and future disputes to mediation, very similar to the definition and explanation of arbitration agreements. But there is no specific consequence for non-compliance. That is, if 2 parties enter into an agreement to mediate, and when a dispute arises, one of the parties say, I don't want to mediate, effectively breaching the agreement to mediate, the Act prescribes no consequences. In fact, there's nothing wrong, and actually it is the right thing to do, to hold a party accountable to what he has already agreed in the mediation agreement. There's no stay of proceedings whereby the court can say, we won't proceed with our proceedings until you go and mediate and give a try at the mediation. There's no stay of proceedings. You will see local and overseas examples for stay of proceedings. In comparable situations, Section 8 of the Singapore Mediation Act 2017 provides for stay of proceedings when somebody is in breach of a mediation agreement. In a more direct way, Section 8 of the Arbitration and Conciliation Act empowers the court to refer the parties to arbitration where there is an arbitration agreement and there is a breach. The Mediation Act has no such stay provision. Why? No idea. Section 20 of the original Mediation Bill 2021, the one of 2021, required the parties to attend at least 2 mediation sessions. And if you fail to do that, a cost sanction at the discretion of the court was provided for. While that is not an ideal state, it was better than nothing. In the Act, however, there is no provision, no compulsory participation or cost sanction. We could possibly argue that under Section 7, as I mentioned, the courts can refer parties to mediation. The courts may possibly use that Section 7 reference to give a remedy where a party comes to court breaching an agreement to mediate. It may work, but from the wording of the section, it looks like it's a blanket empowerment for the courts to refer parties to mediation at its discretion rather than a provision to address the breach of an agreement to mediate. We could also possibly argue that the courts could use their inherent jurisdiction to stay the proceedings. Possible. But when you enact a legislation as comprehensive as this, it's always better to have a clear provision for enforcement of an agreement to mediate. You must understand this in the light of the common law position on enforcement of mediation agreements. For years, for many years, right from 1990, the law is not settled. While the latest trend for the Commonwealth courts is to enforce mediation agreements, it is not settled law yet. So we missed the chance to finally settle the common law debate on the enforceability of mediation agreements in India. A bad miss. Another not so good point about the act is that it leaves out Singapore Convention on Mediation, the biggest global thing on mediation at present. It leaves out Singapore Convention on Mediation totally. The United Nations Convention on International Settlement Agreements resulting from mediation, or the Singapore Convention. It took effect on 12 September 2020. It offers a uniform framework for the enforcement of international mediated settlement agreements. The bigger objective is to facilitate international trade and commerce by enabling easy enforcement of settlement agreements across the borders. Singapore Convention, the work started in 2014 and ended in 2020, is expected to do to mediation what the New York Convention has done to arbitration. As of yesterday, it has 56 signatories, of which 11 have ratified. In the draft bill, when I say draft bill, I mean the draft bill released for public comments in November 2021, not the original bill in Rajya Sabha. There was a dedicated part 3, for the enforcement of Singapore Convention settlement agreements. There was a dedicated part 3, exactly how it should be. But when the original bill was introduced in Rajya Sabha in December 2021, and even in the amended bill, that part disappeared. No mention of the act, no provisions for the enforcement of Singapore Convention mediation settlement agreements. India is a signatory. Actually, it is one of the first countries to sign the Singapore Convention on the day when signatures were opened, but it is yet to ratify it. Most legal obstacles that stand in the way of ratification appear to be resolved by the Act. The definition of mediation is sorted out, enforceability provisions are sorted out, a lot of them. Then why miss this chance? I hear that we fear of unscrupulous parties forging fraudulent settlement agreements in jurisdictions with lesser safeguards and trying to enforce them in India, as if we don't have enough unscrupulous parties. But anyway, there is always a risk. But rather than worrying about it and doing nothing, we should try to overcome that risk. I hear that the drafters pushed for some ways to alleviate the risks, but so far we see nothing. Hopefully, in the near future, we will have a dedicated part in the Act for the enforcement of the mediation convention settlement agreements. But I can't stop saying that we missed a golden opportunity to be in the forefront of mediating countries. And that brings me to the final point, much to your relief, I suppose. The final point I want to make today is on the Act is that it stays too fixated on the idea of pre-litigation mediation. That, I believe, is the baddest, the ugly bit of an otherwise well-drafted Act. Let me explain. We saw earlier how pre-litigation mediation is explained in the Act. It is a mediation undertaken for settlement of disputes before filing a suit or proceedings or civil or commercial nature in any court or tribunal. Simply put, it is a mediation that happens before litigation, pre-litigation mediation, prior to litigation. The original bill, the one introduced in December 2021, proposed compulsory pre-litigation mediation. A compulsory pre-litigation mediation makes mediation a precondition to any suit. So if you were to file a suit, say, of civil or commercial nature before any court, you have to attempt mediation first. Mandatory. Something very similar to Section 12A requirement in the commercial Courts Act 2015, but even broader. In a way, mediation takes over the entire dispute resolution spectrum in the world. Almost everyone mediates in civil and commercial cases. A big revolutionary move. But that proposal met with some serious opposition. The element of compulsion conflicts with the very consensual nature of mediation. Mediation should be one of the options the parties have when they encounter a dispute, not the first compulsory step in any dispute resolution process. And actually, for a variety of subjective reasons, not all disputes are well suited for mediation. I'm not forgetting that only participation is compelled, not the settlement. Now, even if we make such mediation compulsory, do we have the infrastructure for that? Enough space, enough facilities, enough qualified mediators? Simply no, not at the moment. Again, does mediation have that level of public awareness and acceptance? I think the answer is no again. Mind you, most people still read mediation as meditation. A friend recently remarked when he saw this event's poster, "Oh, I didn't know that you are now into meditation. Good for sleep, huh?" Huh? The authorities understood the reasons. Although it was highly touted as this unique Indian idea, compulsory element of pre-litigation mediation was withdrawn. It's not it. Now the amended bill, the act as we call it, makes pre-litigation mediation optional. Withdrawing the compulsory element from the pre-litigation mediation makes sense. I agree. But I don't think keeping the concept of pre-litigation mediation in the act, albeit as an optional one, is a smart move. Let's see. A and B are Indian residents who are parties to a commercial dispute. They go for mediation and settle the dispute and enter into a mediated settlement agreement. How do you label that mediation? A normal domestic mediation? Or a pre-litigation mediation because it's done before litigation? The act says that the parties may consent, have to consent, because it's optional, have to consent to pre-litigation mediation, whether a mediation agreement exists or not. How can you mediate without a mediation agreement, unless the court refers to? When the parties consent eventually, won't that consent amount to mediation agreement subsequent to the dispute anyway? What is the act trying to do? Is it trying to remove the formal requirements of a mediation agreement? So many questions. Even bigger a question is that why we have inserted the idea of pre-litigation mediation in the first place. As I read it, at the best, this is confusing and crafty. Most likely, I think these are litters of its original mandatory character, which are kept in the amended act as well, because the drafters are too fixated with the idea of pre-litigation mediation. We could have done with a lot more thought on that. So, rejoice. In conclusion, there are shortcomings. The toothlessness of the agreements to mediate, the leaving out of the Singapore Convention, the packages, the idea of optional pre-litigation mediation in an awkward way. There is a long way to go. The progress has been slow. It took almost 2 years to get here from the draft mediation bill. And there's a lot of work to do. Mediation council has to be established. Mediation service providers and mediation institutes have to gradually evolve. Rules and regulations must be put in place. But this is a good start. You can't quarrel with that. Consolidation of laws on mediation, enforcement of mediated settlements, all of these are very good. All of these and many other we mentioned earlier are good, great developments. So if I were to summarize my observations on the Mediation Act 2023, I would say this: there are shortcomings, there is a long way to go, but this is a good start for sure. Thank you.
Thank you, Mr. Rajesh, for that detailed exposition on the bill, as well as especially your personal views on many of those specific provisions, and for sharing with us your own experiences of what mediation went through in the ASEAN and in the Southeast countries. Now, I have collated together some questions that have been placed in 3 different platforms, and there are quite a few in number. I've noted down 12 questions. And I think that I will put together all those questions that are on the same subject. I think that I will join them together for the sake of time, saving time. The first question is relating to, as you rightly pointed out and elaborately, the compulsory mediation or mandatory mediation aspect. There is a question by Neelima Mangot as well as Buddhiraja lawyers who would ask that since mediation is voluntary dispute resolution, is it proper to make pre-litigation mediation mandatory? And Mr. Buddhiraja would ask, in Commercial Courts Act, case pre-litigation mediation is mandatory. That's how I can read it from the chat. I think that you have touched upon it and you have mentioned it, but you can add on some points onto it if you want.
I think any form of compulsion to a consensual process like mediation is not proper. To the credit of the Mediation Act drafters, although they came up with this idea of mandatory pre-litigation mediation, they eventually realized that it may not be the right thing to do, and they have changed that into optional pre-litigation mediation, which makes no sense. But never mind, they moved from mandatory pre-litigation mediation to optional mediation. Coming to Commercial Courts Act, if you ask my personal view on that, I think it should not be the case. Mediation in itself innately has this consensual nature built in. The parties should have the right whether to mediate or not. Anything which breaches even the legislation, I don't think is a very good legislation. I think it kills the essence of mediation. Although I must add, in practice, it's not that harmful as I make it out to be in principle. In practice, people sometimes need a bit of a push, and the Act provides that. At the end of the day, they only push to participate in mediation. They don't push to settle in mediation. So it's only a minor inconvenience that you have to mediate maybe for a few sessions and say, I'm not interested, and go back. And that is what many parties do when they don't want to do that.
Thank you. The next question again by Mr. Buddhiraja lawyers is, what are your views about peer mediation? Peer mediation, P-E-E-R.
Yes, I think that is something, when we conceptualized the Center for ADR, we thought of having that even schools and colleges and even in workplaces. Peer mediation can be very effective. It's like a neighborhood mediation, you live at the same place, and then one of the neighbors you have dispute with, another neighbor steps in and tries to help you to resolve the problem. It has some persuasive value. Same with peer mediation in workplace as well as in educational institutions. So yes, it's a good thing.
Thank you. Satya CA asks, party autonomy mediation. So parties could plead for equitable set-off, that is time-barred debts. I think he's asking regarding the scope of it. Party autonomy in mediation. A question relating to party autonomy. To what extent party autonomy has been protected in this bill, or has it been detrimentally affected?
Oh, no. Well, I think we had a session, a major section on it. The summary of it will be party autonomy is well respected, recognized, and given effect to by the Act, except for that small aberration, which is only a practical inconvenience where the courts can actually refer parties to mediation. Except for that, everything is in tune, in line with party autonomy. So it's a good act when it comes to party providing and recognizing party autonomy.
Thank you. Madam from Buddhiraja Lawyers, I've seen you raised your hand. I shall come back to you after completing this chat box questions. Thank you very much. Just hold on a sec, please. The next question, then I can't read out the name because it's just the on plus 1 plus CPH. He would ask, will MCI be an autonomous entity or an institution?
It is meant to be. It is a statutory body, a body corporate with a lot of statutory powers. It's a statutory body.
Oh,
But the problem I see is that a lot of them are, the members are ex officio. Central government appoints those members. So if you're looking at total freedom to work, not sure. But then, you can not want governments to interfere with these bodies, but sometimes it's also a boon, government, the right bureaucrat in the government can help things move. So having bureaucrats in the mediation council, which I think we may have a bit too many, is not a bad thing. But I think people are, if you look at the section on the composition of the mediation council, you will see it's evenly balanced between bureaucrats, mediators, reputed practitioners. So it's a balance, and these are things which I guess we have to wait and see.
Thank you. The next questions, I propose to club two questions together because it relates to the qualification of mediators. The question is from CA Satya again, and the other is from Wilfred de Cruz. And Wilfred asks, Section 10(1) of the bill restricts party autonomy in choosing mediators. He says that parties must be permitted to choose any mediator, and insisting on qualification, experience, and accreditation as may be specified in the rules to follow is bad. And Satya would add on to say why the act is not mentioning about qualification of mediators. So both would ask about the same thing, but different questions actually.
Challenging my knowledge, huh? It's a very complex
We
question.
don't have an option. We don't have any other expert other than you so as to answer these questions.
Okay, thank you, sir. Actually, there is no qualification mentioned for a mediator, domestic mediator. No qualification is mentioned for a domestic mediator. And the parties are free even to name the mediator and to also agree upon the procedure for appointment of mediator. Even when the mediation service provider appoints a mediator, they have to take into account the preference of the parties. So party autonomy, parties' preference is very well protected when it comes to appointment of mediators. They can appoint a specific person or provide for a procedure for that. So they are safe. In terms of qualifications, foreign mediators, I think many are pointing that out as discrimination against foreign mediators. Somehow the act says if you are a foreign mediator, then you have to follow certain, you have to have certain qualifications and accreditations.
Yes.
But that is subject to rules and regulations which are yet to come.
Okay.
That provision, yes, there is a discrimination between domestic and foreign mediators. For domestic mediators, no qualifications are prescribed. For foreign mediators, we may see some qualifications and accreditations prescribed when the rules and regulations comes out.
The next question is from Nancy R. And the question is, sir, is making pre-litigation mediation compulsory more appropriate? I think that you had touched on the matter.
I think
since, yeah, yes. You had mentioned that. So the question is as to whether making it compulsory is more appropriate.
I think it is not. Well, that again, that's a personal view. It would have made some sense, a disagreeable one, but if you put it in the act. Here it's an optional one, and I think you don't need a as of now, as the provision stands, I think it's totally unwanted in the act. Serves no purpose.
The next question is something that we touched upon in the beginning. that is regarding conciliation and mediation. This is a question from Mr. Ramabhadran, and he asks, juxtaposition of mediation and conciliation has been stated as unwarranted. That's his opinion, because conciliation and mediation, he says, are distinct and different. And the conciliator under the 1996 Act, which is the Arbitration Conciliation Act 1996, is more proactive. So what exactly is the rationale in putting them together, or rather making conciliation under the Act redundant?
I disagree with him. I see his view. I hear his views, but I disagree with him. There is a history behind this. I think it's in 1974. I haven't refreshed my memory on this, but I'm trying to recall. In 1970s, early 1970s, when World Trade Organization came up with these UNCITRAL rules on conciliation, it was called conciliation. The definition is the same. It's a third-party facilitator and helping the parties to settle the dispute. So since 74, everyone used conciliation for a very long time. And then based on that, we tried to enact it as a law in the Arbitration and Conciliation Act, and later amended the CPC into Section 89 and tried to define it. The courts followed the suit, and we established something called conciliation as a dispute resolution mechanism. While the global trend moved on, they started using mediation instead of conciliation. No difference in the definition. They just started using mediation, especially in late 90s. I remember in Singapore Mediation Center, Australian mediation centers, they started using mediation, just maybe they fancy that name better. But there is no definition whatsoever, difference in the definition whatsoever between the mediation. And then as it moved forward, more people adopted mediation than conciliation. And then in 2014, WTO, when they started drafting the convention, they definitely used mediation. All the while, then by early 2000s, Indians got a feel of mediation. Then they have to fit that into the system. We already have conciliation. Now you hear another term, mediation. We were not willing to make it interchangeable. That would have been the easiest one. Instead, we celebrated the difference, wrote articles about it, and tried to actively distinguish them. And in the process, what we did is, conciliation is where conciliator is more active. Mediation is where conciliator is less active. So that distinction, to me, is a very artificial one. And I think we went a long way and finally realized that the global trend, we are so totally out of tune with the global trend, and came back and made a correction for that. Now, definition of mediation is a third party facilitating amicable settlement of disputes between two parties. Same as conciliation. The only thing people argue is that conciliator has an active role. The mediator can take an active role, depending whether actually the Act provides for it, that mediator can actually generate options if the parties agree. So that active conciliator role is not totally eclipsed by adopting mediation. So as I said, it's the same to me. An argument is definitely there, especially by in-house lawyers who think that when a mediator proposes some solutions, it's easy for them to go back to the bosses and get that approved, rather than saying that the other party suggested these and we need some consent. So, we have, as I said, that is why I said we celebrated that distinction and enjoyed it. But now I think it has come to an end.
The next question is from Sita Lakshmi, and she would ask, composition of mediation council is a matter of concern. Will there be professional regulators? Do we have enough trained mediators with adequate representation? For example, in the High Court of Kerala, we have enough number of trained mediators. Can we aspire for a situation where there could be a composition of the mediation council by including such trained mediators who are already available?
Well, when I mentioned the pre-litigation mediation, one of the drawbacks I pointed out was that we don't have the infrastructure enough to mediate all the potential mediatable cases in India. We only mediate, according to one report, only mediate 2% of the cases. So yes, even if Mediation Council accommodates all the mediators currently available, we still need a lot more mediators. So it is a growth industry. So definitely, I don't think it will be unwise for the Mediation Council of India to exclude from their purview these trained mediators, and I don't think they will do that.
I do have a couple of questions, but I think that it would be unfair to keep Madam from Buddhiraja Lawyers waiting. So
Yeah.
I would, Madam, you can ask the question.
Yes, good evening, everyone. Myself, Advocate Rakhi Buddhiraja. I'm a mediator in Supreme Court of India. So, first of all, my query is that when we are well aware about the benefits of peer mediation, then why we are not taking care of the peer mediation more effective in schools and other educational institutions?
I did not get the question.
Sir, my question is that when we are well aware about the benefits of peer mediation and government is also well aware, then why we are not making the peer mediation more effective for schools and other institutions?
I think that should be the way. I hope it will be the way.
Sir, my next question is whether the law graduates or practicing lawyer are need of training, 40 hours training of mediator. If yes, then why only 40 hours training?
I think they have to put a figure to it, I suppose. I think it's arbitrary. I mean, like most numbers, it is arbitrary. But I guess 40 hours, I mean, you look at the curriculum of the Supreme Court Training Center, you will see a very well set out curriculum. At least they have 40 hours gives them enough time to cover that curriculum. Maybe that's the reason. I think we need to learn 500 hours to master that subject.
Yes, yes. Thank you, sir.
Thank you, ma'am. I think we will take one more question, and that will be the last one. The question, I think I'm taking it because of its practical significance as a lawyer. It says, it's from Ajit. He asks, Section 8.1 of the bill permits parties to approach courts for urgent interim relief, and that is only if exceptional circumstances exist. And Ajit says the words exceptional circumstances exist. Those words are highly ambiguous, capable of being having many interpretations and also subjective interpretations. So can we have some more clarity on it, or should we have had some clarity on it?
Actually, that was one of the grouses from the bill introduced in the Rajya Sabha.
Okay.
Amended bill has taken it away.
Okay.
So the exceptional circumstances thing, many commentators raised that issue. So it is not anymore. I mean, the Section 8 is now dealing with appointment of mediators. That particular provision has been taken away. So not anymore a worry.
That answers the question. I just hold on a sec. I think Satya CA. Satya, is there anything that you want to raise?
Sir, may I ask a question?
Please go ahead, man. We can't see you though.
Sir, whether our act made for any type of mediation, that is, the mediations are so many types are there now, sir. Facilitative mediation, transformative mediation, evaluative mediation. Our act, our in the mediation bill, which type is more preferable, sir? Which type is they are preferring?
They don't prefer. They actually is trying to be very inclusive. They are saying, as long as, that is why I quoted Juliet from Shakespeare. By whatever name you call it, as long as it smells sweet, it is a rose. So when there is a third party assisting the parties to resolve their disputes, it is called mediation. The nature of the mediation, the behavior of the mediator The role of the mediator, as the parties want them to be, can be transformative, can be facilitative, whatever it is. It doesn't matter. All are considered as mediation under the Act. Very inclusive Act.
Thank you very much, sir. And that brings us to the end of this lecture. Kindly permit me to propose the vote of thanks. On behalf of the Center for ADR Research and Practice, I express our profound gratitude to Mr. Rajesh C. Mutad for agreeing to address us on a topic that is of great contemporary relevance and for our legal system. And I thank the members of the Executive Council of the Center for ADR Research and Practice for all the cooperation and assistance. I thank all the judges, mediators, advocates, faculty members, law students of various law colleges, professors, principals, and all others who have joined us for this lecture. Well, we assure you that the Center of ADR Research and Practice will continue its endeavor to promote ADR, and we shall keep you updated of our future programs. From what Rajesh C. Mutad tells us, the journey of the new Act could be